Hello, and welcome to another edition of Coffee Talk with attorney Brian D. Lerner. In this particular episode, I'd like to talk about a little bit about ethics of an estate attorney. Because it differs a little bit than with other areas of law. For example, in most other areas of law, if you have a client, of course, you owe a duty to that client. Okay, and if you don't have a client, generally speaking, you don't owe a duty to that particular client. Well, in estate law, it is very different than that. Let's say that you have hired an estate attorney to do your living trust. And in the living trust, it states that, your house is going to go to your daughter and your other house is going to go to your son. Well, in this particular regard, you are the one, let's say, who signed the agreement with the estate attorney in which to do the living trust. Let's say the estate attorney never spoke to your daughter or your son, never even saw them, doesn't know what they look like, nothing. However, the estate attorney owes a duty to the beneficiaries of your trust. So, and these are known beneficiaries. So any beneficiary that is going to get something, there is a duty owed by the attorney to that beneficiary. Now, that's really quite unique in law, which does pose a stricter standard on the estate attorney to make sure that essentially he or she doesn't do anything that would take away what the children are supposed to get. And that's why it's very important. For example, let's say later somebody wants to do something that is going to put the house in foreclosure or whatever it is possible that the estate attorney, depending on the circumstances of the case, would have to do something in which to protect the beneficiaries. Now, let's say that the beneficiaries come in a room with the estate attorney and with the client, the one, the one who signed to have the living trust. And let's say you want the beneficiaries to sign something to essentially decrease what they've had, and let's say it's in an irrevocable trust. So let's say your spouse died and you want the beneficiary to reduce their take. Well, the attorney, in that particular regard, would now be in a conflict of interest position because you, the client, wants to do something that is going to hurt the beneficiary and decrease what it is that they're going to get. And so the estate attorney, in that particular regard, would most likely have to withdraw as the attorney of record in which to not have this conflict. Sometimes the attorney can disclose everything to the beneficiary and to you, the client, and how the conflict exists, and have both of you sign a waiver letter of that conflict. But the reality is that many times that's not going to happen, and that still doesn't actually reduce the conflict. So there's lots of different areas and different avenues that take heed in estate law, which both the client and the beneficiary should be aware of. It also is in such a manner that years and years after the trust may have been made, and a beneficiary might come against the estate attorney for not properly protecting them, even though they never signed an attorney-client agreement and they may never have seen each other. Now, this doesn't apply to potential beneficiaries. So let's say, you have 2 kids and, 3 might be on the way in the future. Well, those 3 that come in the future, those will not have any duty to complain about with the estate attorney. It's only known beneficiaries. Okay, so if you like the video, click like, subscribe. More on the coming videos.